Johnson, and on my right is Margaret Ann Wilkinson, and we're going to be, this panel is tasked to talk about intellectual property and intellectual property rights in the Canada-U.S. relationship, particularly examining the protection and enforcement of intellectual property rights in Canada and the United States, and potential methods to achieve convergence. Our first panelist speaker this afternoon is going to be Bill Manson, and Bill's Deputy General Counsel at Lubrizol here in Cleveland, a global specialty chemical company manufacturing facilities around the world, one of the stars of Cleveland. And Bill's been with Lubrizol since 1995, particularly working in legal compliance contracts, product distribution beforehand, and also in the litigation section of an international law firm. Bill is currently Deputy General Counsel, and I should just finish up by saying he's graduated from Bowling Green State University here in Ohio and has a PhD in economics from Virginia Tech in 1980. Bill, why don't you take the floor? It's all yours.
All right. Thank you. First, I guess I should begin with some disclaimers. I'll do my best first to keep you awake for this last hour before you head off to the cocktail hour. And that's not a disclaimer, that's a goal. My disclaimer, of course, is that the opinions are my own, and that really has to be reinforced given one of our last speakers, Cindy, is from Lang-Michener, because when I was asked to participate in this panel, I called some of my dear friends who happen to be at Lang-Michener, Don McCodrum and Peter Wells in particular, and chatted with them about Canadian patent law, and I had spent many years working with them on some patent litigation. And so to the extent I've learned from them and got it wrong, it's certainly not their fault. I guess my last sort of disclaimer goes with a little plaque that I keep on my desk, which is a bit of a prayer, and it says, "Lord, give me this day my daily opinion and forgive the one I had yesterday." In a sense, I hope that what we'll talk about a little bit today is a little bit more lasting than the one day, because it's based on just some observations, and it's based on observations of someone who's been involved with a business that has engaged in patent litigation. We're fortunate that for the last 10 years we've essentially avoided that subject, but for many years before, Lubrizol was engaged in active litigation to enforce its patent rights. One of the things I've learned as an outcome of being engaged in patent litigation is when you meet people from other parts of the industry, you sometimes are asked, well, gee, what value did you get from enforcing your patent rights against that company? And you spent so much in litigation. And you can look at it, and many times you look at patent litigation, think it's really is it a cost-justifiable solution? But the one thing that's so hard to quantify in patent litigation is the message that is sent frequently by companies that you are willing to protect your intellectual property rights, at least in those markets that will accept protection. Today, what I really want to talk about is a business person's perspective of enforcing patent rights. I should say again, my last disclaimer is I'm not an IP practitioner. I'm not a member of the IP bar. I don't file patent applications. So when we get into the technical subjects about what's patentable, I really can't address those, and I'll look to my learned colleagues on the panel to address those. But I have spent time with the very important part of patent law, which is once I get a right, what can I do with it? If someone is infringing my patent, what happens? Where do I go? And in particular, we have been involved in litigation on patent rights both in the United States, as a company, both in the United States and in Canada. And some of my observations are based on our own experience and just the experience that you observe when you're involved in litigation in the various countries. We have to start this by remembering that patents are creatures of national law, and the fact, like every other regulatory subject that we have, that you're addressing during this conference, that there are going to be differences. The laws in Canada are different to some extent from the laws in the United States. And we'll be talking, or colleagues will talk a little bit about that. From my perspective, there's a great deal of similarity in some of the fundamentals of patent law. But when we then get to looking at enforcement, again, on the surface, there appears to be a great deal of similarity between the laws of the United States and the laws of Canada, but there are some very subtle differences which can make significant cost differences for the party that wishes to enforce its patent rights. Before we get into really looking at that, I'm going to suggest that we just have to remember a little bit from a business perspective, why we go after patents and what the costs of getting patents are. Obtaining a patent, it doesn't come at zero cost. The process is, can be expensive to obtain, expensive to maintain, and indeed expensive to enforce. The mere fact that you get a patent, while it may in fact come with the presumption of validity, doesn't mean when you take it to a patent litigator, that patent litigator will look at you and say, I can win and enforce that patent in a given court. So the mere fact that you have it doesn't necessarily mean that you're going to feel comfortable enough to enforce it. But I want to take a business person's quick look and say, where do I need patents? And one of the things we think about internationally, and certainly across borders, is, do I need a patent in every jurisdiction? Will a patent in the U.S. suffice? Do I need a patent in Canada? Do I need to patent in various jurisdictions in other parts of the world? If I were to, for example, go to some countries, would it be worth my time to patent if they don't enforce the patent rights in those countries? And one of the things that we need to look at is, from a business perspective, before we even get to the question of enforcement, is what is the nature of the market? Where are the goods being made? Because perhaps if in your industry the goods, there are economies of scale, there are relatively few manufacturing facilities, perhaps that will help guide your patenting strategy. Clearly, if you have a competitor on the other side of the border and you want to be able to exclude them from your invention, you're going to want to be able to have a patent there, so to ensure that they're not, in fact, manufacturing something that would infringe your rights and distributing it. If a patent in one country will effectively foreclose a competitor because of the way goods move, you may not have to have patents in every country. From an owner's perspective, when we think about starting to look at a patent, we want to think about where is the claimed infringing activity occurring, or where is it expected to occur, and which courts have jurisdiction to address the issue. This is, again, once we have our patent, we believe someone's infringing our rights, where is that happening? And then, as we look at North America, which side of the border is it happening on? Where's the manufacturing? Where are the distributions? And if there are two forums where there's infringement in both, one will have to at least ask the question, should I begin and push my litigation in one of those courts more rapidly than I do in the other court? Again, I always have to think about my statute of limitations on my claims, but it may very well be valuable to make that decision of where I want to first pursue, or do I want to simultaneously pursue. And we're going to be talking, because I'll be talking a little bit about those procedures a little bit later. But as you think about that enforcement decision, you start to think about what are the costs, what's the extent of the infringement in each forum, and what's the effectiveness of the remedies that you can get. If I bring a suit in Canada, will I be better off? Will the case move more quickly or more slowly? What kinds of remedies do I get if I want to push my case in Canada first? Will I be able to get an injunction? Will I be able to do something which effectively affects both markets? Those are all decisions we want to be able to look at. Now, the fact of the matter is, the first thing that anyone looks at in a jurisdiction is, can I get an injunction quickly? Can I get an interlocutory, a preliminary injunction? And from at least our perspective, those things are available on both sides of this border. So, the fact of the matter is, from my perspective, you don't have a huge amount of difference there. You have the potential of achieving that level of relief. But there are differences when we look more closely at Canada and the U.S. system. with respect to the type of monetary remedies that might be available. There are also differences about the nature of the process and the procedures. Think, for example, in various countries, the way you go about litigating, it can be very different. If I were to bring a patent case in the UK, in principle, I get a judge who's come out of the patent bar who is a specialist in patent litigation. If I bring the case in Canada, I at least conceptually draw a federal judge, which could be any of the federal judges, not necessarily one who has experience in patents, although I guess some people might argue it's the assignment might move to, since there are certain members of the federal bench there with extensive patent experience, my understanding is they may draw more cases, and that's efficient. Although I don't believe there's any formal rule which would guide any cases in Canada that way. South of that border here, it's a random draw. You can draw a federal judge who is going to be very, well, I can't say he or she will be antagonistic to patents, but they could show a very great dislike for having the case and having to deal with the types of technical arguments that arise in a patent case. On the other hand, you may get, and there are some wonderful judges who feel very, very comfortable handling patent cases, and if indeed you're starting litigation, you just hope to draw some of those people. But the other point that's really different for a lot of people, apart from what type of judge you're going to draw, is in the United States we have the jury system. So do you want, and that's, many management teams might look and say, do we really want to have a case where the jurors are going to be deciding whether or not our chemical structure was patentable? And, I know there are a few people, possibly in this room, who may have abandoned their language courses and taken organic chemistry because they found it easier. But for many people, once you get into those discussions, it becomes a very frightening matter. And to be having an entire case dealing, in front of people who may not have, certainly may not have a university level of education, or even if they did, may not have any type of science background, can be a scary thing. On the other hand, there are many people who will argue whether it's that type of case or some other case, it won't matter. But, that is something one has to consider. Judge, specialist judge, jury, doesn't matter to you as a decision maker. To me, as someone who's been involved in a lot of litigation, one of the bigger differences on the two sides of the border is the nature of discovery which takes place in the case. Now, I began my law practice before a lot of the great advances in electronics, so I remember sitting in a workroom, a war room that was filled with three-ring binders, which were all the depositions of the huge number of witnesses whose depositions were taken for days in a case. That is the nature of American proceedings. You will get documents, you will get huge numbers of depositions, and then you'll start turning over and start doing the experts and spending a lot of time. One of the things we found, I'm just going to jump back here. One of the things we found when we litigated in Canada is, to me, and something to consider, it sometimes seems like the process, at least in principle, might be a little bit more efficient. The nature of discovery is a little bit different in Canada. It is a little more limited. Arguably, at least under the Canadian system, they'd say it arguably gets to the point and helps to avoid perhaps some of the extraneous matters. When you're pursuing all those other depositions, you'd argue, yes, you may miss some of the key points. So the role of discovery and the cost of discovery in modern litigation is a huge consideration. And it's one I would think people will consider if you're looking at starting your case north of our border or south of the border. And another aspect is the time to decision, the ultimate decision. In this case, it's really hard for me to determine. I don't, perhaps one of my colleagues has seen the process. At one point, I used to think that the Canadian process might work more quickly. I don't believe that anymore. I think it's both. I don't think it's much worse. Except in the United States, there are a few jurisdictions that do have a very rapid procedure, the so-called rocket dockets. And in those cases, it will be expensive, but you will move quickly. But for a general case, I'm not sure there's a huge amount of difference. There is one other aspect that I find interesting as an American litigator when you do it. In Canada, you wind up with many interlocutory appeals, something you don't see in the United States. So many things that could be very interesting early in a case may want to be taken up on an appeal, and at least you'll get some level of resolution early. That won't happen. On the other hand, in the U.S. litigation, you have certain procedures to at least start claims construction determination by the judges early, our so-called Markman hearing process, to try to at least get a judge to start defining the patent claims that are going to actually be litigated and to tell us what they really mean legally. In Canada, I understand, I've seen at least one case where someone attempted to have a Markman hearing. The trial court gave them the equivalent, but then the Court of Appeals felt it was inappropriate to do that, I believe, on an interlocutory appeal. And they felt that might be a good process and it might be something that Canada should look at, but it shouldn't be a court deciding it. So, just one of the differences. As I said, just to turn back for a moment to the remedies that are available, I think in both jurisdictions you have the ability to seek interlocutory or preliminary injunctions. Damages obviously are available both in Canada and in the United States, but there are potentially some different remedies in Canada. First, you can ask the question, in the United States we always think of big jury awards, and at the same time you can also think of big punitive awards and punitive enhancements. The patent law in the United States does allow a punitive enhancement. It allows, under the appropriate circumstances, it allows a multiplier of the damages that are found in the case. In Canada, that multiplier effect doesn't exist. I think in theory there might be some potential for a punitive damage, but it is very limited. I mean, in the case of Lubrizol won a 15 million Canadian punitive damage award when a preliminary or interlocutory injunction was violated in the case, but that eventually the Court of Appeals said no, that was the inappropriate number at the time. We'd have to wait till the end of the case to determine what the appropriate number should be, and the matter was resolved, so we don't know how that would have gone. The general principle north of the border, as I would understand it, not only in this matter but in others, is that it's just less likely for you to get enhanced damages in Canada. The U.S. would be much more favorable. There is something, at least on the books conceptually, that might make Canada interesting, and that is that you can at least request, you may be able to elect an accounting of the infringer's profits if you prevail. Although that was, I will tell you in practice, something that Lubrizol had endeavored to do. That process never came to fruition, went on for a number of years, and the case eventually settled. And my understanding of Canadian jurisprudence right now is that the value of that claim may be more limited. There's been some jurisprudence which requires people to look at best non-infringing alternatives. That was a question before. But theoretically, there is there is the potential election that if you win a patent case, instead of showing the damages directly to you, you may be able to seek to get, I'll call it, disgorgement of all the profits that the infringer made. That is something that's not available in the United States. The other remedies, the more traditional remedies in terms of getting lost profits or royalties, I think there are some case law variants, but both those two principles are available both on the north of the border and to the south. One other difference is recovery of costs. In exceptional circumstances, the U.S. courts might award attorney's fees and costs. They can be awarded in Canada, but at the same time, you're not going to get the full costs that a corporation or people have actually spent. And so whether that's a valuable remedy or not to you, it is something that does exist in Canada, and in general doesn't exist in the United States. As I said already, their discovery issues are different. In the U.S., we do have very broad document and deposition discovery, where in Canada, you do have documentary discovery, but you have oral discovery of a party, and you can have the inventors and the assigners, but it's a much more limited oral discovery, which can make the case somewhat more cost-effective. Again, from your perspective, you have to decide whether or not you're getting the information you need to litigate in that, and that may be something that plays in your decision analysis. There's another difference. I want to spend my last few minutes, I didn't look at when I started, but my last few minutes talking about a few other procedural differences. And one, so I'm going to start with the role of experts. It's at least my perception that coming out of the UK or Canada, there's at least still more of the feeling, I won't say illusion, although I wanted to, but the feeling that experts still have a sort of rarefied aura, that they should be more independent. In the United States, I think we long ago sort of recognized, well, we give the experts certain latitude to give their opinions that we won't give other witnesses, but at the same time we recognize and we allow a lot of cross-examination to say we recognize they're being paid to give their scientific opinions. The approach to the experts in Canada is sort of interesting, and it's been leading, I think, to something that, as I understand, was recently being considered in Canada. It's a procedure that has this lovely image to me. This is referring to the hot tubbing of experts. And it's a procedure that's grown out of Australia, because the feeling was, well, these experts, it's really hard to go into a litigation and have experts coming at us and talking and all, and we can't sort it out. Maybe what we ought to do is put them all up at the same time and let them all sit there and talk to each other in front of us for a while. And I've still not seen the demonstration, but from what I have read, Australia has been using this procedure and setting aside whatever images might come to mind about someone sitting in the Calgary winter and talking about patents in a hot tub. The fact of the matter is, at least the Australians believe, it's a very useful tool. And I believe in the recent round of discussions in the federal rules, it was at least something that was being considered in Canada, and it hasn't been completely ruled out. My understanding, it was at least, as it was originally proposed by some in Canada, was that experts might be able to ask experts questions and have discussions without the lawyers present. And that was ruled out. But the concept that you might have some procedure to simultaneously give evidence of competing experts, I believe, is still potentially going to be available in Canada, which is a real difference. Now, I will tell you from personal experience, it's been interesting to watch, because I have been involved in some mediations where mediators wanted to do that and have done that. And they have basically taken the lawyers out of the room. Again, it's a mediation, it's voluntary. And the mediators sat with the experts, and they talked expert things, about the issues in the case. Now, so there are certainly a group of people who believe that by doing that, it will help get them to a resolution. I don't know. I haven't actually gone through it, and I'm not sure I'll accept it purely on faith of the Australians that it works, but it may. At least it may work in certain circumstances. Jump ahead here. The last thing I want to talk about in terms of a procedure, and this relates to dealing in any two jurisdictions. If you have a potential patent fight that could be brought in the United States, or would likely be brought in the United States, and could be brought and would likely be brought in Canada, you have a number of coordination issues that you really have to worry about. And one of the main ones, in my view, is the loss of privilege in the process. In sort of the UK tradition and the traditions that Canada has adopted, there is, it appears to me, a greater willingness to keep, we have solicitor-client privilege, but to keep litigation privilege on documents. In the United States, there is very wide open discovery when you get to an expert. So if you've had the same expert testifying in both jurisdictions. And that is something that is very likely to happen in a patent case. When you think about other types of cases where there's multi-jurisdictional issues, if the issue is boiling down to economic damages, I can find an economist in any jurisdiction. If the question is how is somebody hurt, they're normal, and it's a normal medical issue, I can find doctors in many jurisdictions. But if I'm getting into a very technical question, an industry-based question, and I want to talk to what was the state of knowledge, did someone reasonably skilled in the art understand at the time of that patent, the pool of experts may shrink considerably. And so there may be a much smaller set that I want to use. And I may want to be using the same expert in more than one jurisdiction. When that expert appears in the United States, the rules in the United States are generally going to tell you that everything that expert's seen that's relating to that case may have to be produced. So if there was material that was given to that expert in the Canadian litigation, and maybe he hasn't even testified yet in the Canadian litigation, and maybe that material should be privileged in the Canadian case, the U.S. rules may require him to divulge that. Again, I just point out, we're dealing with two types of privilege, and I see this as being not as much a solicitor-client, as it would be called privilege from Canada, or attorney-client privilege. I see it more in the Canadian rule of parlance, the litigation privilege, when you have to give something up. And indeed, I also believe that in both, going back to UK roots and in Canada, you have more of a concept, even with solicitor-client privilege, that there can be a limited waiver. That is something that I believe is far less likely to be the case in the United States. It's much more likely that once you have a waiver of any aspect of something in the United States, the courts are going to say you have waived privilege with respect to the entire subject matter. There are these procedures in other countries that might say we can't have a limited waiver. And I just want to give you a couple of examples to that. I'm going to jump ahead here. Given my time, oops. Come back here. There are two types of things that have come up that are interesting. One was in a process of seeking a Moreva injunction in Canada. There was, a U.S. lawyer went in and disclosed certain material to support obtaining the freezing order, the Moreva injunction in Canada. And the process of filing that caused the waiver of privilege. Again, it is becoming the interaction of what you're doing in one jurisdiction causing a potentially negative outcome if you haven't thought that all the way through. A more entertaining case, though it's not Canadian, I wanted to highlight it, is a case that came out, it's now a decade old, but it was Borns versus Raychem in the UK, and that was a case where during the taxation process for costs, Borns and Raychem had been in litigation in many jurisdictions, and something was produced, and you can't tell what it was, in the opinions, but something was produced that the U.S. lawyers for Raychem said, well, we need to take this because we don't want to walk back to I believe it was the California courts, and we want to show that what we lost before, somebody had obtained it through false or fraudulent evidence. And that was an issue in front of both the trial level, Mr. Justice Laddie in the UK, and then the appeal with Justice Aldous. And essentially, it highlighted an interesting principle of a limited waiver, because they said what they gave up in the taxation proceeding could still be considered privileged, and they wouldn't let the documents go out of the UK. I believe Canada might be closer to following that. Certainly in the United States, I don't think you have a hope once something has been given up. Just to one last war story, because I assume my time's about up, is in the Ubersol case, we had the same type of matter in court. We had the situation in our case in Canada where we had one expert. He had testified in Canada. He, quite frankly, was, I didn't see that trial, but my understanding is he did a powerful job. He was a wonderful polymer chemist. He wrote in the leading textbook, and years later, he was in other cases, and this gentleman was a retired scientist who at the time had just gone through some surgery, and he was late 70s at the time. And during his numerous days of depositions, he said certain things which were somewhat inconsistent with his Canadian testimony. And eventually it led to a whole new procedure under Rule 1733, a whole new trial, which was actually longer than the first trial. The gentleman, when he had been 10 years younger, I think had spent a couple of days on the stand. When they brought him back in the 1733 hearing, he spent 2 weeks on the stand. And I believe the first trial was 29 days, and I believe the second trial, about whether he had testified correctly, was about the same number of trial days. In the end, there was opinion by Mr. Justice Nadon, which completely exonerated him, but it was an interesting point. The takeaway is not so much what happened in that case, other than the process that when you have given testimony in one case, that will come back in other cases. And the best learning is that you better remember it all as well as you did the first time, because you will be, it's very likely you will be questioned on it if you're an expert. And that really makes it a very difficult situation for experts in cases. Because, people long ago, when I started being a litigator, they said, well, litigators have sort of bathtub mentalities. They sort of fill up the bathtub with all the facts of the case, and as soon as it's over, you pull the plug, it's all gone. And even for an expert, it may well be that, a lot of the nuances of the case you knew at the time. And if it's a scientist, there's, what I've observed is that they'll know their science continually. But the nuances of the case, they may not remember exactly. And that can be a very difficult problem when you are using an expert in more than one jurisdiction, Canada to the United States. And again, it's compounded by the fact that some of the work that may never have had to have been produced by the Canadian courts the first time around, but in the United States, when he testifies, all of it will have to be produced again. So let me end my comments there and turn it over to my colleague to talk.
So that was very interesting, and I'm assuming we're holding that question until after both of you speak.
Technical staff find the correct program.
I have a lot of follow-up questions for that. I'm sure other people do. Our next learned speaker this afternoon, Margaret Ann Wilkinson, professor at the University of Western Ontario, faculty Western Ontario. She's in the Faculty of Law. She's practiced in Toronto for several years, joined the Faculty of Law in 1991 and became a full professor in 2007. Professor Wilkinson has spoken and published in the areas of intellectual property, information and media law, information policy, including health information policy, as well in the areas of management professionalism and professional ethics. So we're very pleased to have Professor Wilkinson here, and Margaret, the floor is yours.
Thank you very much. I'm pretty sure that the Wilkinsons are all timetabled between you and food on this program today. Our conversation is about harmonization, and I was looking at things, and for me there's a threshold question about whether or not harmonization is always a good idea. And I think there are some areas where it's maybe a better idea in both the national interest of Canada and the United States to leave countries free to go their own ways to experiment. And so I'm going to talk to you about one area where I think that too early harmonization might be a problem. And it's partly because I think that we have areas, and intellectual property is one of them, where we have tremendous difference, I think, in our national social orders that make it difficult to decide how exactly we're going to harmonize for best economic effect overall for North America. So the issue that I think is a challenge is the way our two countries tend to be approaching secrecy. And so, and secrecy in an information economy, and an evolving information economy, is hugely powerful. And I think Canada has two inconsistent things going on, which make it difficult for us at the moment to be a consistent player in deciding how to manage the secrecy. And I'll say a little bit about that. So from an intellectual property point of view, what I'm talking about is the protection of a confidence as an independent action, independent of contract. For Canada, that is a huge new area which only developed in Canadian law in 1989. So in intellectual property law terms, this is a very, very new game for us. And we will recompense the confider for a breach if the subject matter was secret, and then only if the confider told the confidant in confidence, and then only if the confider suffered as a result of the confidence breach and the confidant benefited by the breach. And I'll refer to this again, but there's a couple of things just to point out that make this difficult in an intellectual property context as we move the discussion forward. At this moment, this is purely judge-made law. So this is a decision of the Supreme Court of Canada, and there are good reasons in the Canadian context for suggesting that we should leave it alone, because it is judge-made law. And I'll come back to this. But in other areas of intellectual property, we legislate at the federal level. If we were to legislate this area, then it would become open to charter challenge. And that might be a problem, whereas right now it is judge-made law as an action between private parties, and for good or ill. I'll also draw your attention to the third element of the test, where we say if the confider suffered as a result of the confidence breach and the confidant benefited by the breach. And so we have kind of a two-part test there from both sides of the secret, which I will come back to later. But that third part departs significantly from the language that is in both NAFTA and in TRIPS. Makes it a little harder in the Canadian context. Now, from an intellectual property point of view, and some other people have spoken of this before, but one of the things that I think is challenging in this conversation is that it's only since NAFTA and TRIPS that we've actually talked about protection of a confidence as being intellectual property, because we stuck them in NAFTA and TRIPS in the chapters on intellectual property. And I would argue to you that fundamentally they're probably not intellectual property, because the intellectual property devices were always designed to give an enhancement for giving up secrets. That was largely the impulse for both copyright and patent protection, and of course trademark is always in the hands of the public. So confidential information, it seems to me, is a completely different conversation and perhaps shouldn't be talked of in the same ways. I also think, and I would defer to my colleagues here that are in business, but at some level I'm not sure that you actually need an international protection of a secret that you have secret in a particular jurisdiction. So I think we might want to come back to that conversation later. So one of the things that we've done in Canada, and I don't think we've fully thought about what we've done, is that in the same period of time, from 1989 to the present on the confidential information side, and from 1975 roughly to the present on the personal data protection side, we have allocated control over data in certain circumstances to two different sets of players. And we haven't really thought through exactly what it is we think we've done with that. And I'll show you in a moment, we're even a bit confused within the systems about what we're doing. So this is actually the slide that Paul Mayer might have wanted for his talk. This is personal data protection in Canada. It's a fully matured scheme in the sense that it exists in every province, in every jurisdiction. It's fully worked out. So, however, it is completely inconsistent across Canadian jurisdictions. Never mind, across borders. And as you see at the bottom of the slide here, we have three different sets of things happening. We have one set of personal data protection legislation that governs the 14 public sector jurisdictions, which can even differ between provincial and municipal levels, depending, and varies quite widely. We have a second set of things happening. That set, the number one set, which is the oldest set, is always paired with access legislation. And I'm going to come back to this in a minute, because one of the things that has happened, because that personal data protection legislation is always paired with access, It's actually, the access part means that the protection of confidence in the business context is actually always broken when information goes into a public sector organization. No private sector organization can guarantee a confidence if they've had to disclose information to government, because you lose the confidence, and I'll show you that in a minute. Or you lose control of the confidence, because the control is now vested in the statute. And those elements are all inconsistent as well. And it means that Canada is actually confused now, because personal data protection paired with access is something that is older for us. So we understand personal data protection when it is paired with access to government information. We now have a second wave, which is personal data protection covering the private sector only. But even within Canada, the courts don't really fully understand that second thing, because it's not paired with access. There's no intention in Canada that that private sector organizations would have to give up their information to an outside requester, unless it is the requester who is the subject of the personal data. Okay? And then, because we're confused, we have a sector where there are public and private sector players, major PDP activity in PPPs, public-private sector partnerships, the health sector. So at least 4 jurisdictions have tried to bridge differences between our public sector legislation that's paired with access legislation and our private sector legislation that is not paired with access legislation and medicine. And the blue means that the Ontario's health sector legislation is the only one that our privacy regulators have accepted as being fully formed privacy regulation. So if you actually do a study of this, many organizations operating in Canada in different jurisdictions have to comply with multiple personal data protection regimes right now at the same time in order to move anything along. And so what has happened with that then is that we've actually had a little bit of confusion about what's happening between sectors. So personal data protection law is in rhetoric considered to be privacy law in Canada. But in fact it's not privacy law. Because privacy law, we have very, very little privacy law in fact. We have 4, the only province that has fully developed privacy legislation. That is, you cannot take information from me in a particular circumstance. For example, the classic case, it's Quebec that has the most well-developed, and the classic case is a picture was taken of a woman on the steps of a public building. It was published in an art magazine without her permission, and the entire issue was deemed to be fall afoul of the privacy law. Personal data protection legislation isn't about that at all. It's purely a controls mechanism. It says if an organization gets information about me, then we would have to, I would have to have opportunities to access it, and I would have elements of control. So it gives me power, and it's essentially about power, really. It's funny, I went upstairs here, and I see open files with people's names on them on the second floor here. I don't know if that's just local practice, but that would be completely illegal anywhere in Canada now because of the personal and private sector legislation. You couldn't have those sitting out like that. So it's just a small change. So this personal data protection legislation, when you look at it closely, it actually is like confidential information in the business context. Confidential information in the business context is in the control of the business. But in Canada now, it's in the control of the business except if the information relates to an identifiable individual, in which case we have statutorily given that control to the individual. And as you can see, that's likely to make some clash of cultures. The other thing that is interesting is that in the personal data protection sphere, we have given time limits, like we do in patent, like we do in copyright. But in confidential information, because it's a common law protection and it's judicially made, there's no time limit on it at all, which again takes it away from a classic model of confidential information. So I just want to indicate to you two things here. First of all, when I talk about information going into government, all these 14 different jurisdictions in Canada with inconsistent legislation, they all have what is called third-party protections, which is in personal data protection language, the protection for a business confidence. And I've just shown you two examples here. They're all worded differently. And they don't all conform to the common law test that I showed you on the first slide. So, for example, the federal protection of third-party information is wider than Ontario's by a large margin. So a company, given a choice, would prefer to give information to the federal government than the Ontario government, but of course, as you know, doing business, that's not how it works. You have to give the information to the jurisdiction that is giving you whatever benefit you're after. And so there's currently quite an inconsistency there. There's another confusion, which I'll just show you quickly here. This is the Supreme Court of Canada getting itself mixed up. This is an access case. So this is a requester asked for information from the Canadian Food Inspection Agency. So it's an access case. The Canadian Food Inspection Agency, in turn, thought that the information being requested involved Heinz, one of our Leamington companies, actually. And so they, third party, gave Heinz a notice that there was a request for their business information. Heinz was unable to make out the case that the information was really business information, but they thought to themselves, oh yes, that would be customer information. So under personal data protection principles, customer information shouldn't be released if it was about personally identifiable information about a customer. So they then raised that with the Canadian Food Inspection Agency. And access to the information was denied. But what's wrong with this from a power perspective is the identifiable informations about people, about whom the information was at issue, were never even told the litigation was happening. So it wasn't that they raised an objection to the use of their personal data, it's that their power over their personal data was appropriated by the business for its own interests. And that just can't be the right analytic way to go about this. So we're not quite sure what we're doing. So just to show you here, what's happened in Canada is we have completely different things happening if you are classified as a public sector organization than if you're classified as a private sector organization. If you're classified as a public sector organization, you don't have the breach of confidence action or the full protection of that area of law available at all. Okay? You are completely governed by access legislation. You do have personal data protection legislation with which you have to stringently comply, but it's time limited, and there's nothing to do with privacy in terms of being a public sector organization. In the private sector, on the other hand, confidentiality is a very strong protection, unless you have to give information to government. But personal data protection is also competing interest, which you've only had to deal with in the business environment in Canada fully since 2004. So when you put this all together and you then look at NAFTA and TRIPS, one of the questions that you would have to ask is whether Canada's really close. I mean, it's close, it's clearly close, but is it fully compliant with its obligations? And if it isn't fully compliant with its obligations, what on earth could it do about that? Well, that's a really interesting question. And I put the parts of the part 1, part 2, part 3 on this slide are the parts of the common law test expounded by the Supreme Court of Canada, all of which have slight frailties with either NAFTA or TRIPS, which, in a paper I would go into at great length and explain to you, but there's a little bit of frailty there. In terms of forcing us being Canada, to live up to our obligations, we have a huge problem, because we would have to legislate to live up to our obligations. And if we legislate to live up to our obligations, Then we put ourselves into a space with the charter. And the charter has, Canada's Supreme Court calls privacy quasi-constitutional and calls privacy in Quebec, which has a statute which is its charter, a charter value under its charter. Confidential information has no charter place at all, and freedom of expression has every charter place. So, who should be balancing this for us is a very tough choice. And I think it's a place where, as a country, we need to be able to work out what it is that we think we're doing before anybody tries to harmonize with us, or before we try to harmonize any more than we already are with anyone else. Thank you.
Mr. Wilkinson, that was very well done. Thank you. Do we have any questions for two esteemed panelists here? Litigation cross-border, confidentiality. Dick?
Dick Cunningham. One thing that I think might be useful to add in the discussion of intellectual property litigation and comparison between the two countries is we do have in the United States another route to patent and other intellectual property litigation, which is Section 337, which has both a nightmare quality to it, because if you've ever done it, it takes a nice leisurely 3-year patent litigation, and with all the discovery, all of the depositions, all of the hearings, all of the motions, and compresses into 4 months. But it also has an overlay on it of public interest and trade-type injury tests to it. And in some areas it has particular utility for patent questions that rise to levels of public policy. And we just had one involving a big dispute between General Electric on the one hand and Mitsubishi on the other over patents for wind turbines, in which the patent issues got blended with the public policy issues about the development of wind energy in the United States, and the various agencies, we got various agencies involved on supporting Mitsubishi's position not to limit competition, and that actually won the case. But it's an interesting addition. It's something you don't have in Canada, and it's something that ought to be considered in the mix in terms of what is the right approach, particularly on international focused patent and copyright and trademark issues. Particularly patent and copyright. There's not much trademark there.
Yeah, the procedures at the ITC are interesting. But unlike, for those who aren't familiar with it, they're really efforts to stop the importation of something which is infringing. So you're stopping something at the border, and that can include the whole product that contains the infringing material. And they do move quickly. Been involved in those cases in the past. They do move quickly, and you do get the injunction effect. You don't get the damages. It does have the overlay of a public involvement. The ITC can have people, I don't know if they did in your matter, who might sit in on the depositions, and they may assign staff attorneys to monitor or be involved in the case, because they can be as active as they choose to be. It does move quickly because it moves through an administrative law judge, and then then you have your appeal processes. But it is a little different in that it's really to stop things at the border, not the infringement taking place by something made within your jurisdiction.
Well, they do have cease and desist orders as well.
Yeah.
I just want to comment that I think that the Canadian trade lawyers would very much like to have a similar process in Canada. So I think that, unless Mr. Herman has a different opinion than I do, but I think that the Canadian trade lawyers have been suggesting for a while that we harmonize with the U.S. on having a similar procedure.
We have another question down here, and I might add, we also have pretty effective customs rules, particularly for trademarks and copyrights,
Yeah.
not for patents. But those can stop things at the border even faster than an ITC proceeding, and I don't know if Canada has a similar process. Question?
Hey, Michael Robinson, it's a question for Margaret Ann. It's a really dumb one, but I know almost nothing about the charter because it always scared me. So, and I'm a sort of business lawyer. But I always understood that the charter didn't protect any business, corporate, commercial rights. It protected individual rights. Can you help me with how the charter issue arises in terms of a business confidentiality agreement that may be signed? How do you sneak in the charter?
No, at this moment, you're totally right. At this moment, when we're looking at confidential information as being protected either by private contract or by the common law action for breach, there is no charter opportunity. And I'm saying to you, I suggest that's possibly a good thing as we move forward with developing these protections, right? What I was saying to you is that if there is a problem, because Canada now has obligations in the area of protecting confidences under NAFTA and TRIPS, one way of fixing that would be to legislate. If we legislate, then the legislation itself is taken as a government activity, and that legislation becomes subject to charter scrutiny. And the Supreme Court of Canada has indicated very clearly that it will treat intellectual property statutes as reviewable under the charter. So, and we didn't even get into it here because we haven't got a lot of time, and it'd be fun for another year because we're still waiting for somebody to do something. But I believe we've been waiting now 3 rounds for copyright reform. We've had 2 bills die on the order paper. We had another consultation in August. We're, any minute going to have a bill. And I think what's holding everyone up, or one of the things, I mean there's lots of things, but we do have a strong tradition of users' rights language in the Supreme Court of Canada. Rights language does invoke charter kinds of thoughts, and that would be a problem if what the thinking otherwise would be to tighten the hold of copyright holders. So that's what I was thinking about. If we legislate, we open ourselves up to challenge. And the Supreme Court of Canada has given indication in other areas of intellectual property that it will think about charter.
Question?
Just to follow on, my name is Jim Mauer, just to follow on what Margaret Ann was saying about the copyright. Canada signed the World Intellectual Property Organization treaties, I guess, in '96, and this domestic copyright reform, one of the objectives is to implement these treaties. And my question to you is, do you see, we're trying to focus on harmonizing regulations, do you see that in the area of intellectual property, this harmonization will take place via international treaties that are negotiated, and then you'll have domestic implementing legislation, which will be quasi-harmonized because everybody's trying to implement the same treaty?
So specifically with respect to the copyright debate, this is a hot issue. I'm not sure, it's a very hot issue certainly socially in Canada. It's a very good idea, I think, maybe to do comparative patent litigation, because we don't actually litigate that much copyright, but the reform of those bills is a huge issue. And there are 2, I think, major points in contention. One point is, given that we've signed the World Intellectual Property Organization treaties and they've come into force, to everyone's, or at least some people's surprise, I think, is how much further we have to go in our current law to comply with them. The second thing is whether the urging of models taken from the United States are actually much further than we would have to go. And our government has a problem in that in 2004 we have a major decision of the Supreme Court of Canada which says that fair dealing is a user's right and explicates it rather more fully than we've had before. And we're now working with that. We are using that and expanding it with decisions of our copyright board. We're just trying to make it work. So there are major challenges for the government in trying to move forward with this legislation. And it's not a popular topic. So I don't think they're that eager to introduce it because it can't, there's no way you can win with that legislation. So I don't think they're that eager to bring it forward. And the argument that you're making that Canada must comply with its international obligations is seen as an argument for copyright holders largely. Copyright users are all making the argument that we have users' rights in Canada. So the language is becoming polarized.
No, I'm sorry, my question was not so much where, we don't have to sign on to the white paper, there's no obligation. I mean, we've signed it, and if we don't want to ratify it, we won't ratify it. My question is not so much that we're being forced to do this by international treaty. It's more that, do you see that as we move forward, more and more of our domestic IP legislation will flow from treaties that we voluntarily signed, and we want to sign them, it's in our national interest, and that is the way that we're going to harmonize in the area of intellectual property, is by signing international treaties, implementing them, and that will force the harmonization that we've been discussing over the last couple of days. Do you see that happening, or am I right in hearing what you're saying, that there's a disconnect between what Canada's signing internationally? We may never ratify because we've moved on with the Supreme Court of Canada CCH decision. We're moving into a different era, and therefore we can't really implement this treaty that we signed but we've never ratified.
I think we're on the same conversation. I apologize if I didn't express myself correctly, but I think there is an argument in the current copyright debate in Canada that we have a moral obligation to implement those WIPO treaties because we signed them. And that has become part of the rhetoric. So we've now got a rhetoric that's got, never mind what the merits are, you've got two rhetorics of right. Right in our international obligations and right in our users' rights. And that's always a challenging space to be in when the government's trying to move forward at all. So if you take the example of what's going on with copyright, leading by signing an international convention has, I think, made it extremely challenging for the government to actually get the reform, even if it's a good reform. We've now put ourselves in a place of competing rhetorics. I'm not sure how that's going to play out. And just in connection with that as well, the conversation about customs regulation, that I can fully understand that conversation perhaps in the patent environment, but in the copyright environment, I think the customs regulation is in the past. It can't help us at all because we're talking almost entirely, the debate is in the electronic environment, and customs doesn't help us. It's all about who's downloading what and doing what with it.
If I may, Larry Herman, you raised the question of protections under the NAFTA, and that Canada is close, but we may not be fully compliant. But just a comment, in order for that issue to be raised as a NAFTA issue, one of the other NAFTA parties will have to bring us to a NAFTA panel. And that's the only way in which the breach of an international treaty obligation under the NAFTA can be litigated. And that would mean that the U.S. and Mexico would have to bring this forward as a dispute, and it doesn't seem to me to be very likely that would happen. And even if it did, a NAFTA panel can award compensation to the injured country, as it were, and it can't force Canada to change its legislative framework. So it's sort of theoretical. It's an interesting point, but it's very, very theoretical. We often hear in Canada suggestions that Canada isn't compliant with its NAFTA obligations and the country should do or the government should do less and so. But in the real world, somebody some other government has to bring that forward as a dispute, and that dispute has to be litigated. And it's really totally academic because the NAFTA panels couldn't award anything that would force Canada to change its law. They couldn't award compensation and couldn't provide a right of retaliation on the part of the other government. So we're really not getting anywhere in raising those issues. That's my opinion.
Thank you, Larry.
Um, I think it's sometimes the role of the academic to raise the academic point, but in the Canadian context, I think the Heinz litigation indicates that the relationship between personal data protection and confidential information is something that is going to, I mean, business is extremely well aware of the burden that personal data protection places on it and the vulnerabilities of it. So I agree with you that it's academic at this time, but I think that there could, it could actually become live.
Well, it may not be academic in this sense, that it is possible for a Canadian litigant to raise the issue, and the courts have said, as you well know, that Canadian law cannot, depends on the context, but Canadian law cannot be inconsistent with Canada's treaty obligations. So there could be a remedy in the Canadian court system, but certainly not a remedy in terms of international treaty obligations under the NAFTA, even if we were to breach, even if Canada were to breach.
Yes, Mr. Humphrey.
David Fong here. Again, I do not privy to all the intricacies of different legislations. But what I've experienced in intellectual property issues has been that small companies are subject to the bullying of major corporations by taking them to court and denying the rights to under the patent law, simply on the basis of high cost of litigation. So I've seen one of my friends in Boston go bankrupt because one major corporation decides to take charge of his patent and use it and say, if you don't like it, sue me in court. What are we, is anything being done in this process that would level the playing field? Or are we just continuing to allow this to happen, to push forward with more shell corporations, picking up all the patents from all the small players, and then going after all the major corporations on a vulture type of basis?
That's a real good question right now, because I work for a large company, and even a patent litigation for a large company is a big pill to swallow. But actually, it kind of segues into a question I had, is that if you had the same dispute in Canada and the U.S. was a patent dispute, suppose you had approximately the same amount of dollars at stake, is there a, would you choose Canada over the U.S., all else things being equal, to take your suit because one might be less expensive than the other? Is that an opportunity for cost reduction?
Well, I think it could be cheaper in Canada. You have to weigh that against the potential for the enhancement in damages. If you take the hypothetical you gave for the situation that may have actually occurred if someone is an egregious infringer, a willful infringer, and you would have a situation where you may well get the enhanced damages, again, if you can survive. And certainly there are examples of companies that have worked out their arrangements and have fought through and in fact, won their cases. But that is a problem with litigation. There's no two ways around that. Litigation is expensive, and patent litigation is particularly expensive.
Do you see that in commercial dispute, we have come to that conclusion, and so now we are all putting in a clause about arbitration to avoid the high cost of litigation? Do you see the development of the use of arbitration as a means to resolve intellectual property disputes?
That's something a lot of people we've talked about. I will tell you, my experience has been that I look to arbitration and I would support arbitration in many contexts. certainly in international context. In international context, even covering intellectual property, because for many countries, it would be easier to take an arbitral award and get it enforced than it would be to get a litigation award enforced. Having said that, if I'm within my own jurisdiction, if I'm in the United States, I have carved out intellectual property and not taken it to it and said I'll arbitrate anything except the ownership of intellectual property. And that's just, my company's bias, that we have had more faith in when you've had two bites at the apple and things have gone through the Court of Appeals, that we'll get to the correct decision. And we've seen situations not directly affecting us where we felt, we know what happened, we felt the arbitration was wrong, and it was, it's talking about the ownership of a very significant asset frequently, and I may want my appellate rights.
Of course, arbitration can't help the situation you gave us a moment ago, because in the David and Goliath situation, there often wasn't a contractual relationship that could have created the arbitration. So, the litigation, squashes the small player.
I understand exactly that. What I would like to suggest is that if, in fact, arbitration from the legal professional perspective is a more equal, fair way to deal with an issue like that, which I understand it may not be. In Canada, I think there may be the mood to use legislation to like a small claim court issue, that for a small player, they have the ability to go to a small claim intellectual property court to have it settled in a manner that they would not be disadvantaged by the size differences of the two entities.
Or perhaps going to a patent office and having them figure out infringement, which happens in some countries. I agree. I think in the next couple of years, people are going to realize that the patent system is somewhat broken and that it costs so much to take these cases to trial. I think it's driven a lot by discovery, e-discovery. You don't have that issue in other countries, like over in Europe. You don't have as much discovery. You spend hundreds of thousands of dollars in e-discovery. We're getting estimates of $2 to $3 million for a patent case. I mean, large companies can't even afford that, much less smaller companies. So what do? We've got to come up with an alternative here. Plus, at the end of the day, you may not, there's a case that came down a couple years ago, you may not get an injunction. You may not be able to stop these people. And the worst case scenario is that they walk away with a reasonable royalty. I mean, tell me that that's a good spend of $2 or $3 million just so the other side can walk away paying a reasonable royalty. That doesn't make sense for someone to make a significant investment in technology. There's got to be a reason for patents. You have to be able to get a good patent, enforce it, get someone to stop using your invention, and get a reasonable settlement.
One thing, though, in a perverse way, perhaps, things like e-discovery may actually work in favor of the small company. If you take sort of the extreme example of the electronics company built in the garage, and you say, I want all your electronic records, they'll say, good, copy those 2 hard drives. We're done. In the case of a big company, you're dropping $1 million to get the e-discovery. And it can be, now then you can impose the burden, and there's questions of what you'll have to reimburse from that. But it might be a bit of an equalizer. Not enough to address your entire problem, but I see it as a little bit of an equalizer.
That is also the context of the hot tub discussion in Canada. I have also heard that. I doubt very much we're going to have the hot tub, but the context did arise in terms of trying to get, take things at an early stage and go straight to the technology so that a small player wouldn't be disadvantaged.
I will tell you that one of the things that we have experimented with in litigation, it's not a rules issue, it's a private matter, is to get we've worked with early neutros in patent cases, and we've worked in some matters where we've said, look, we don't want a mediator, but we've got someone who both sides respect and say, we're going to give you a quick outline of the case, and we'll have senior executives who are going to listen to what you say, and that's going to guide an early negotiation. And we found that to be a very effective way to get through some disputes earlier than anything would have happened in the court. And And so there are some creative things that can be done by parties who are being cost conscious. That again won't address your situation if one side is just saying, I'm going to act unreasonably and try to impose lots of costs on you. This assumes companies or parties, individuals who have a similar cost-conscious approach to resolving the dispute.
We're kind of almost out of time, maybe last question.
Michael Robinson with another short question illustrating my level of ignorance about litigating patents. But having listened to the research and motion chaps complain loudly in writing and orally here and elsewhere about how badly they were abused in the U.S., I had thought that was the place to go if you were attacking a patent, because there's some federal court judge in some area, I'm not sure what it is, that you go to and gives you an injunction at the blink of an eye, and then you're forced to settle. As we know, the president wasn't prepared to give up his BlackBerry, and the FBI was wanting to block the injunction too. But it is maybe that's just our misunderstanding of what goes on in the U.S. In patent litigation. But I would have thought, in terms of where you want to go, you go to that judge.
Well, I think, you can get an early stage interlocutory preliminary injunction in either country in principle. I think, clearly the market in the U.S. was big, and they were able to do, and they got the result they wanted, when they were attacking them. And as we said, you could, the potential for damages then in the United States can be very large, and especially with the enhancement. And traditionally, if you win that first injunction, you're pretty much, you may be home. You may continue on. That's the big step in many patent cases.
It's very hard to get injunctions these days.
Yeah.
I find that very frustrating being on the other side.
That's not what RIM says. They were very upset.
Well, it's changed. When I have patents to enforce, I have to wait 2 years to get a ruling, sometimes 3 years, to get a ruling where I can stop the other person from harming my company, throwing the people out of work because we can't make the product anymore because it's shipped over to another country or another manufacturer. I got to wait for 3 years before I can finally get a permanent injunction, and now we have a case that says you're not even entitled to a permanent injunction. So I'm actually going the other way. Well, anyway, any other questions? Or I think we're wrapping up here for our afternoon session. Thanks very much for everyone and our panelists. And I think we're adjourned for the day.
Thank you again. Just some logistical information. We're on about a 45-minute break, so to speak, just to stretch your legs. It was 85 degrees Thursday. I would have encouraged you to go outside then, but it's a little bit different today. But we will be reconvening at 5:30. The reception will begin upstairs. Everything will be held upstairs this evening in terms of the reception. It'll be immediately followed by the dinner. You'll see the setup. So please join us about 5:30, and then at 7 o'clock we'll start the presentation of the Henry King tribute and the presentation of the awards. So we'll see you. And this, as I said this morning, is a time for camaraderie, the other part of this conference, to build those professional and personal relationships. So please take a little breather. Well, since you were the late crowd, we'll buy everybody a drink, so to speak, for sticking through the day, and we'll see you at 5:30. Thank you. All right, Andy.
Well, that's one it's about time, Tanner, you showed up for the drinks. All that. Here, you don't want to go with it. I do that all my hand up. Also makes it look like it's more, giving them more. Yeah. Take 4 pages.